As we enter into 2021, the CRA, the Canada Revenue Agency, will be provided with a lot more information regarding your income and other tax information. As a result, the CRA will be able to conduct more thorough investigations on people's eligibility for the CRB, the Canada Recovery Benefit, which people have been and will continue to be applying for. In this video, I'm going to show you the different ways the government is allowed to investigate CRB applications, what your rights are if you're told to repay a benefit, and what you might be expected to pay based on the CRA's findings about your application. So we're going to take a look at the Canada Recovery Benefits Act. This is the law that was passed that created the CRB, as well as the sickness and caregiving benefits, and in it, it contains the authority given by Parliament to the CRA in terms of administrating these CRB applications. Under Section 26 of the Act, the CRA is allowed to make you provide any information or any document within a reasonable time stated in the notice. The CRA is also allowed to make you show up somewhere, or through video or audio call, in order to get any information from you that they need. And under subsection 3 here, it tells us that if you do not comply with these demands of the CRA, you would be ruled ineligible for the CRB, and so you would have to pay back your benefit, assuming there's no further penalty. So this is a very powerful tool that the CRA has to investigate people's CRB claims. They can ask you for basically any information or document to verify that you're eligible for the CRB, and if you don't give them what they're asking for, you are automatically ruled to be ineligible. In a similar fashion, they can compel you to do a video call or audio call with them to provide information they need regarding your eligibility for the CRB, and again, if you refuse, you're automatically ineligible. So the point here is that the CRA is not just limited to the stuff you submit online or over the phone at the time you're applying every 2 weeks for the CRB for verifying if you're eligible or not. They can ask you for any other supporting documents or information. Some of the additional documents or information that they'll need for verification, they can keep adding by putting more and more steps to the online process, but some of this stuff will be the specific documents and information that they'll need from specific individuals, and so they'll contact them directly for it. Now, that's just the power that they've been given under the law, but in reality, will they conduct a thorough investigation for everybody? Probably not. In theory, when you file your income taxes every year, every person could be audited to see if their tax returns are properly filed, as the CRA could ask you for all of your documents and investigate you closely. They have the power to do this, but in reality, we know that it doesn't happen. We have a self-reporting tax system for everyone, and the CRA chooses some of those people to be audited each year. So I expect something similar investigating CRB applications, where some people will be investigated closely and asked for additional information and documents, and others may not be. I'm not saying this to scare you or encourage you about how the CRA will verify the CRB applications. I just want to give you some understanding of why there could be a situation where you might get asked for additional information or to do a video call with the CRA, but your friend who applied for the CRB also doesn't. By the way, just in case you were wondering, in the law it says the minister may, which is referring to the Minister of National Revenue, who is the head of the CRA, who can then delegate this power to the agents working at the CRA. Now, one important thing people are wondering is, if I'm actually ineligible for the CRB payments that I've been receiving, when would I find out about that? When would the CRA actually tell me, hey, you actually don't qualify, you need to pay us back? In Section 30 of the law, it tells us that the CRA can reconsider your application up to 36 months after it was paid to you. So after you receive a 2-week payment, the CRA has 3 years to then change its mind and tell you, no, you were actually ineligible, pay us back. Hearing 3 years can make us a little bit paranoid, thinking that you might have to pay back these CRB checks so far into the future. But it's not as bad as it seems. It's not like they're slowly building up information about you day after day for 3 years to then make a final determination in 3 years about whether you were eligible or not. Realistically, the purpose of this time frame is about getting all the relevant income information they need for the period of the CRB that you applied for. And so normally your income information would come with your income tax filing in the following year, right? So for example, if you applied for the CRB in January of 2021, you wouldn't need to file your 2021 income tax return until April 30th, 2022, almost a year and a half later. So as a result of that, the CRA would need to give themselves at least a year or two, depending on when you applied and when you filed your taxes. And so they put an additional year of time just in case you make amendments to your tax return or anything changes. So that's probably what this 36-month time period is for, likely to give themselves the time to get the tax information for the periods of the CRB that you applied for, and see if based on that your application was valid or not. Okay, so let's say 3 years later the CRA decides you're actually ineligible. What happens then? In Section 28, it tells us that if you receive the CRB and are determined to not be eligible, or you receive more than the amount you were eligible for, you have to pay that amount back as soon as possible, and it's considered a debt to the government. Now, when the CRA makes this decision that you were not eligible for a CRB payment, they will contact you notice of this decision, and you have the right under Section 31 of the law to request a review of this decision. And you need to request this review within 30 days of receiving the notice from the CRA. It says the manner of this review will be established by the CRA, so they'll tell you what you need to provide. Generally speaking, if we compare this to objecting to when the CRA gives you a notice of assessment for your income tax return, you would have to provide supporting information and documents to show why they made the incorrect decision, and that you're actually eligible to receive the CRB payment. The CRA would presumably tell you why they decided you were ineligible, but it would be your responsibility to convince them otherwise with your evidence in support of that eligibility, meaning the burden of proof is on you. And at the end of the review process, the CRA will notify you whether they still find you ineligible or they've changed their decision. Now, let's say you decide not to request a review of the CRA decision, or you do request a review and you lose. So we now know that you owe a debt to the government for the CRB payments that you received. And if you don't pay this debt back, the government has the authority to garnish your bank account or garnish your paycheck, meaning that they can go take money from your bank account or take your paycheck and use this to pay down the debt that you owe to the government for receiving the CRB when you shouldn't have, or receiving an excess. In Section 33 sub 2, the CRA is also given the power to take the money from any checks you get from the federal government, except for the child care benefit. So, for example, HST credits or tax refunds if you're owed one. Of course, you never want to be in this situation. If the CRA decides that you were actually ineligible and you have to pay back your CRB, they'll get in touch with you and tell you this, and then you need to pay back that amount right away. If you can't afford to pay it back right away, get back in touch with them to figure out some sort of payment plan to do so, because if you don't, then they think you're not going to pay them back and they'll garnish your bank account or paycheck as mentioned. Now, going back to that 36-month time limit, where the CRA can legally decide you were ineligible for the CRB payments you received within 3 years of receiving them, it actually goes further than that. They can actually decide you were ineligible 6 years from when you receive a payment in some situations. These situations are when the CRA believes you have made false or misleading statements or representations in connection with your CRB applications, and this is under Section 30 sub 5. So does that mean if they think you were lying, they can make you repay your CRB back in 6 years? To figure out exactly what this provision means, we can look to the Employment Insurance Act, the law that regulates the EI program, because in the EI law there's a provision that's almost word for word identical in Section 52 sub 5. So what has this section been interpreted by the courts to mean? The courts in this EI context have defined that false statements or representations are ones that don't correspond to truth or reality and are erroneous, whereas misleading statements or representations are ones that lead somewhat astray, which cause error, confusion, or deception. So what we get from this is that false or misleading statements don't have to be lies, they can just be things that aren't reality or cause error. So that would tell us that even mistakes in your application could be considered a false statement. What about this in the opinion part? Specifically about this provision, the courts have found it to mean that as long as the government is reasonably satisfied that a false or misleading statement exists as part of your application, then they have up to 6 years to reconsider your application, meaning decide that you were not actually eligible to receive the payments. And this part that says in connection with an application means that it's considering all of the statements or documents that you provide in the history of your application. So it's not just limited to the details you provide the first time you apply online, it would also consider any false statements you make when further information is requested from you. And so this section altogether basically means that you don't have to be lying as part of your application. You could have just made a mistake, and that they don't have to prove that your statement is false. They just have to be reasonably satisfied that it is, in order for them to get up to 6 years to reconsider your CRB eligibility. But remember, for them to take advantage of this 6-year time extension, the CRA must provide you notice of specifically what part of your application they think is false or misleading. And you would still have the right to request a review of that reconsideration within 30 days, as I mentioned earlier. So if the CRA says something you provided or said was false or misleading, you can refute that by providing evidence that what you said was true and not misleading as part of the review process. So if you prove that the statements you made were not false or misleading, you could still actually be ineligible for the CRB. But if 3 years have passed and the CRA were relying on this 6-year timeline, then they can no longer reconsider your CRB eligibility because they don't have the authority anymore to rely on that 6-year window. So you don't have to be lying for the CRA to reconsider your application for up to 6 years if something on your application wasn't true. But for the CRA to penalize you under this law, they do need to prove you're lying. Under Section 35 Sub 1, it tells us that a person commits a violation of this Act if they knowingly make, in relation to an application for a benefit under this Act, a representation that is false or misleading, or make an application for and receive a benefit under this Act, knowing that they are not eligible to receive it. So the key difference in this section is this word knowingly. In the previous section, you didn't need to know what you said on your application was false or misleading. You could have just made a mistake or not realized. And so in cases like that, the CRA would make you repay the CRB payments you received. But if you knowingly made false statements on your application or knew you weren't actually eligible, then this wasn't an accident. You told the CRA things you knew weren't true, and so this opens you up to extra penalty beyond just having to repay the payments that you received. So how would the CRA prove that you knew those things were false? How could they prove what's going on in your head? Well, first off, they wouldn't need to be 100% certain that you knew, but on a balance of probabilities, meaning more than 50% likely that you knew it was false. Another thing is that they don't need to prove that you were actually intending to defraud or deceive the CRA. All they need to prove is that you knew something was incorrect but submitted it or told them anyway, because that's knowledge of a false statement. Also, even though it's supposed to be only your knowledge, the CRA is allowed to consider, quote, common sense and objective factors. This means that if something is obvious, something that everyone is considered to know, and you're claiming that you didn't know, they're allowed to infer from that you're probably lying. It also depends on what types of questions or requirements you provided a false statement to. So for example, if a situation or question is very complicated and confusing, you are more likely to make a mistake and provide a wrong answer honestly and not knowingly. But if you're asked simple and straightforward questions and you're providing incorrect information, it can be inferred from that you know you're giving false or misleading answers. So you can see based on these different factors how the CRA could potentially prove you knowingly provided a false statement or knew you were ineligible, despite the fact that only you really know what's going on in your head. As it says in subsection 5 though, if you mistakenly believed that what you said was true or you mistakenly believed that you were eligible, then you're not committing a violation and cannot be penalized. And again, you can always provide additional facts and information to the CRA to show that you did not knowingly make false statements, as Section 37 allows a penalty to be reversed on that basis. Now, what is the actual amount of the penalty if the CRA proves that you knowingly gave false information? Further down in Section 35, it tells us that the maximum penalty is 50% of the benefit that you knowingly gave false info about, and the maximum of all penalties you can be given is capped off at $5,000. So for example, if you were found to be lying regarding 2 CRB periods, and for each of them you received $900, so that got you a total of $1,800, then along with paying back that $1,800, you could be penalized up to another $900. You'll notice that it only gives us maximums of 50% or a total of $5,000, but that there's no minimum penalty. And that's because it's completely up to the CRA whether to give out a penalty and the amount of it. In subsection 6, it tells us that the purpose of penalties is to promote compliance with the law and not to punish people. And again, going back to the EI Act, which has a similar discretionary policy for penalties, what we can assume is that the CRA must take into account all of the circumstances of your application and situation, and as long as it does that and does not conduct itself in a perverse or capricious manner, then they can basically choose whatever amount they want. So realistically, they would be looking at factors like how blameworthy was your false statement, how much in CRB benefits did you claim based on that false statement, what's your financial situation, what's your personal situation like your health, mental health, education, and again importantly, what amount, if any, would be best for promoting compliance and not just punishing you. One distinction I want to make is that the penalties in the CRB law are only additional money you would have to pay the CRA. These are not criminal sanctions or any other type of offense that would leave you with a record. It will obviously be on record with the CRA that you were penalized, but it wouldn't be relevant to any other organization. There is, however, a separate section for offenses in the CRB law, and these are things that you would be prosecuted for in court and be convicted if you're proven guilty, with a maximum sentence of up to 6 months in prison. And based on the fact that these are criminal sanctions, obviously what you have to be accused of is a lot more serious in nature. So in Section 39, it tells us the different offenses. If you use a false identity or someone else's identity to apply for the CRB, or if you counsel someone to apply for the CRB and you're going to steal a substantial portion of that payment, And lastly, if you make 3 or more false statements or representations as part of your applications, and the total amount of the benefits are at least $5,000. This last one is basically a much more serious version of what is considered a violation for penalties, because you have to be making at least 3 false statements and receiving at least $5,000 of benefits. So that would be around 6 CRB period payments. And just like with the penalties, if it's a mistake you're making, you're not knowingly making a false statement, and so it wouldn't count as part of the offense. Anyway, because these are criminal offenses, you would be entitled to innocence until you're proven guilty, and to a trial before a judge where the Crown must prove beyond a reasonable doubt that you committed these offenses. And so it's not just like a simple process where the CRA makes their consideration independently and you can request a review, which is like everything else I've been talking thus far. Just as a last note, one interesting thing I found, going back to section 30, this time subsection 4, it says that if the CRA rejected your initial CRB application, but it turns out you were actually eligible, then the CRA has to pay you your CRB check, presumably within 36 months. This is kind of weird because the way that you apply for the CRB is very black and white. If you check off all the boxes on the CRA website, you're automatically paid your CRB check. I'm not aware of anyone whose application would be rejected initially unless they don't check off one of the required boxes on the website, so I'm not sure how this section of the law could apply. Perhaps if the application was done by phone or some other method and there was a mistake made, or possibly if they later on amend the requirements for the CRB, such that people who were rejected for not meeting a certain criteria when they initially applied would now qualify and should be paid for those periods that they were rejected. Anyway, I hope this was a helpful video for you to understand how the CRA will be verifying people's CRB applications, what time frame they have to do so, and what can happen if they decide you're ineligible, and obviously the more serious consequences if you're deemed to be providing false statements in connection with your eligibility. As I said before, the main crux of the CRA's information will be based on your tax returns in 2021 and 2022, and so you want to make sure those are handled on time, diligently, and accurately to minimize your chances of any issues relating to the CRB payments that you have received and will receive later on in 2021. As always, this is not legal advice, this is just legal information to get you acquainted with the CRB law. If you have specific questions and need advice for your situation, please consult with your own lawyer. And please make sure to like this video and subscribe to my channel for more. Until next time.